Yes, Mr. Mansfield, are you ready to carry on?
Yes, thank you. The references, if the list could be put up again, I'm sorry, I should have said rather. These list in 7.2d, Appendix 1. We got down the list to the element of ventilation. It's 2/3 of the way down. There's only one point after this I want to address you about. The references to the ventilation problem comes in the position statement by PSB earlier this year, and it's page 19, paragraph 71, 71 through to 76. Basically, Ryden had reported a fault, potential fault, with the AOVs, the automatic opening vents, that they weren't operating, in particular not opening. And that was followed up with a series of letters. So it's just before the fire, the 6th, the 8th of June, the 12th of June, 2 on the 12th, where there was conversation effectively about who's got the maintenance contract, but nothing was actually done. So therefore, may I pass from a non-effective ventilation system to the next item on the 7.2d. May I make it clear that I'm not suggesting it's a statutory provision, but it is referred to in the statute. So it's a really guidance which we say effectively has that status. Evacuation arrangements, I'm not going to take time on it because you've heard there weren't any. There was no plan for evacuation, there was no training for evacuation, and fire officer after fire officer really knew nothing about it. However, linked to that one is the question of stay put. And I do want to address you in the final moments of what I have to say on that topic, because we are suggesting a reversal of that policy. In other words, that the emphasis is put on get out and stay out, which used to be the cry from many fire brigades across the United Kingdom, and was the policy at the tower before the refurbishment. Could we have, Ralph, the next document? I think you have a slightly different reference. So you have seen this before. Mr. Millett has put it to witnesses. It's a notice to residents. This one that I'm using is attached to Mr. Shahid Ahmed's statement. He's been referred to more than once, and Mr. Leslie Thomas did as well. He recorded a great deal of material, this being one of them. In case of fire, this comes from the RBKC, essentially use the nearest telephone and call the fire brigade, dial 999, and ask for, that's gone blank. State clearly, presumably where the fire is. Inform the porter, which I've already mentioned, there wasn't one after refurbishment. Do not use the lifts. Leave the building using the staircase. Close all doors. Do not re-enter the building. So that was done at a time when there was a single staircase and so forth. And we say that should be reconsidered as the way forward. And we say it has to be reconsidered right now because there is real confusion about the situation now. As Mr. Walsh said yesterday, it's counterintuitive to stay in the building, you want to get out. And as Mr. Menon said today, that is in fact what people are doing. The fires on June the 14th this year, 2 on the same day, 1 in Scotland, 1 in London, in fact. People took no notice of what they were being told to do. They did not stay in, they got out. Because Grenfell, the image of Grenfell is far too great. And we say, quite rightly, that it should be in their minds. And of course, if it were to be reversed, there may be exceptions, but if it were to be reversed, it would make it much simpler for the residents because the emphasis is on get out. And of course, it would also require a fire alarm that sounds and communications within the building and all the rest of it, because if you didn't know there was one, you couldn't. So you have to be alerted to this, and that it is a premise that there will be a way of alerting everybody in the block. Very important, again, if there are floors beyond the 10th which cannot be served by the fire brigade putting out fires on the outside or the inside. Particularly important for them. It's easier for the controllers, because basically they have one line they're going to be putting. Get out is what we are saying as a matter of policy. Don't stay in. And also it would obviate this need that when the controllers were answering questions, I just, as it were, asked that this be considered in parenthesis, how many times were controllers making an assessment which was entirely false and disbelieving what the caller was saying? Now that can't be right. They wouldn't need to go into all that because the policy is get out. And interestingly, I don't think the person who saw it managed to get the registration number, otherwise I think Mr. Walsh or perhaps others will say, where's this fire engine? A London Fire Brigade fire engine was noted very recently to have on its side, if there's a fire, get out. So there are mixed messages being handed out at the moment, never mind the intuition, and never mind the past policy. It has to be addressed so that the public, facing, as everybody's admitted, there's likely to be, as there has been this year, more fires unfortunately, and we say that if there's a presumption, if we put it that way, a presumption in favour of getting out, then all the difficulties, although there are still difficulties facing people trying to get out, at least as Hannah herself said to you, who's part of her evidence I want to read in a moment, that she's riven by the death of her brother, who she overheard being told essentially not to get out. And so it's had a searing effect on the families that this advice of staying put was being promulgated throughout these calls, or most of them anyway, there are one or two exceptions. And of course it's premised on something we say is flawed. In other words, the whole idea is built on a building requirement of compartmentation. And that's too big a risk. Not every building is going to go up in the same way, obviously, but the variables that can go wrong because there's a human hand here in the building, the maintenance, and all the various other machinery involved in this, that therefore being able to say, well, provided we have compartmentation that is sealed, who knows that? At the point of fire, the controller? No, I don't think so. The fire brigade? They might assume it. And those who live in it might assume it. The problem is there are too many assumptions for the stay-put policy to remain. And therefore, the confusion, in a sense, is aptly illustrated not just by the fire engine we've mentioned, nor by the previous notice, but we're obliged to the Royal Borough of Kensington. I don't ask for the document to be put up, but you will find in their recent response a letter dated the 8th of June. It comes in a sort of an attachment to their statement. And may I just read one paragraph? What residents of the Royal Borough of Kensington are now being told is this, or some, not all. So there's no consistency about it. There may be very good reasons why they're separating it out, but this is what it says. Fire procedure for Campden houses. As part of the Council's ongoing commitment to meeting the most stringent standards in fire safety, we are making sure that you're aware of a change to the fire procedure for your block. If you are alerted to smoke or fire within your block notice, and we accept this as being sensible, you should immediately leave your flat, closing your front door behind you, and exit the block via the main entrance door. So we say you have an example there of what should be now considered, and it's a bit, I suppose, like the moratorium on combustible materials. Certainly on non-combustible, that you don't use them. There's, in a sense, a moratorium at this point. We're in a transitional phase while this inquiry is going on, and it would help if you were able to provide some guidance about how this should move forward, rather than, as it were, leaving it for a later period. And just on that topic, if I may, we appreciate the pressure on time for you and all the other things that you and your team have to deal with in the interim. and that once we're not sitting, it's not as though you're not addressing all the issues. However, the latest indication from you that you can't do the hearings into interim recommendations, one of which is going to be possibly the end of January or the other the beginning of February. Now the problem with this is really rather obvious, that if we don't have the hearings fairly soon, let us say March, the hearings that is in relation to only interim recommendations, and then that's got to wait until, I obviously advocating something different, but if that's got to wait for the Phase 1 report, which may or may not, I'm not wishing to preempt how long it's going to take to actually put that into format that can be received by the public, possibly June, July, maybe later, a matter which only you and your team may be able to assist upon. One can see 2 years have gone by since the fire. And that is why we would say, and I did say in August, and I say again, and I'm not embarrassed by having to ask you to reconsider the possibility of identifying within the recommendations those that you can do something about now. We call them manifestly obvious. Now, I appreciate in your ruling earlier, you made a very pertinent point, namely, what's obvious to me may not be obvious to someone else. And one appreciates there's always that. However, that's been the problem for 45 years. People have been waiting for some kind of unanimity. There never will be complete consensus. And provided you're not proposing something that's completely mad, and that is not plainly on the agenda, if you're dealing with the kind of things that I've suggested, you can identify those, hive them off, and have, as it were, a fast track that allows the public to see we, as an inquiry, as a whole, as a collective, are in business, and the business of safety. And it's in that light, really, I'd ask if you kindly put up, it's the last reference. This is Hanan's, I'm calling her Hanan, I hope she doesn't mind, Hanan Wahhabi's evidence, which is on day 70, 8th of November. It comes on pages 189 onwards. Could I have 188? I'm going to shorten it. Instead of reading a lot of it, I'm just, at the bottom of that page, there, line 21 on that. This witness you will remember clearly because of all the other circumstances surrounding her giving evidence and being able to give evidence. And you very kindly indicated that it was perceptive and powerful at the end. And what she said towards the end is at the bottom of that page, the impact it's had, that's the 72 people who passed away, we can't bring our loved ones back. The impact it's had on our families and our community could have been prevented. We can't change that now, but we can change the lives of those we've lost to count for their deaths, not to have been in vain. There has to be change. We have to learn from this. Life will never be the same for us. We may find a new place to live, but it won't be our home. Grenfell was our home. The people who were there were our family. The impact on me and my children, all of those impacted, will last a lifetime. And I want to know that we will be supported for the rest of our lives. As a result of this inquiry, I want the truth to be found and for change to happen. And then she finally wants to thank all of the people, including the inquiry team, who have continued to help us. It makes a huge difference. And words will never be enough, but from my heart, thank you. And it is really in that context that I urge you to reconsider, as it were, the fast track. Something is done now that can be seen, that is perfectly acceptable, reasonable, and will not require too much extra effort. But I think all of us here are quite prepared to lend our help to your team to ensure that that product can be achieved. Thank you.
Well, thank you very much, Mr. Mansfield. Now, Mr. Beer is going to make a statement on behalf of MHCLG. So I'm not going to rise for a moment, so I'll just sit here quietly while you make your way up, Mr. Beer.
So the department has been following the progress of the inquiry closely, and it reiterates through me its commitment to supporting the inquiry in its twin objectives. Firstly, to get to the truth, and secondly, to ensure that lessons are learned so that a tragedy like Grenfell can never happen. Dame Judith Hackett's independent review of the building regulations and fire safety highlighted that the current system is, quote, not fit for purpose. Nothing more is important than ensuring that people are safe in their homes. The department is determined to learn the lessons from Grenfell and to bring about a fundamental change in the building safety system. Accordingly, the government will set out how it intends to take forward the recommendations of her independent review of building regulations and fire safety by the end of this year. And so that everyone is safe and feels safe in their homes, a comprehensive building safety programme was put in place within days of the Grenfell Tower fire. The government is taking action to speed up the refurbishment of unsafe cladding, like the type used at Grenfell Tower. The government is fully funding the replacement of unsafe ACM cladding on social sector buildings 18 metres or more in height. In the private sector, the government is supporting local authorities to take decisive enforcement action where remediation plans for high-rise buildings with unsafe cladding are unclear, and this includes providing additional guidance on the assessment of such buildings and the setting up of a local government association-hosted joint inspection teams. Local authorities are getting the government's full backing, including financial support where this is necessary, to enable them to carry out emergency remedial work on affected private residential buildings and unsafe ACM cladding. They will recover the costs from building owners in doing so. The department wishes to ensure that all core participants are aware before the 14th of December deadline that you have set for submitting submissions on proposed interim recommendations, that the department has acted to impose a clear ban on combustible cladding for high-rise and some other buildings. Whilst the department is clear, having taken advice from experts, that unmodified polythene cord ACM cladding does not comply with the requirements of the building regulations as they stand, concerns have been expressed that combustible cladding is not explicitly banned under statute. Following detailed consultation earlier this year, which attracted over 400 responses, the department laid regulations on the 29th of November 2018. Under these new regulations, building work must be carried out so that only materials which meet classification A1 or A2 S1DO under European standard EM 135011, other than certain components which are exempted, become part of an external wall of buildings 18 metres or more in height, and which contain one or more flats, a hospital, residential care premises, a dormitory and a boarding school, or student accommodation. In the meantime, the government is not waiting for legislative change to begin fixing other parts of the system. It is supporting the remediation of other buildings with unsafe cladding, testing and improving the safety of fire doors, and working with so-called early adopters to test new approaches and to achieve change on the ground as soon as is possible. We acknowledge that the inquiry has, of course, received written and oral expert evidence from a range of experts, and the department will address the issues raised by those experts in their subsequent evidence as appropriate during phase 2 of your inquiry. Finally, the inquiry stands ready, in particular in phase 2 of the inquiry, in any way that the inquiry sees fit, and will take account of all issues raised by the inquiry through its work, as it itself takes forward the building safety programme.
Good, thank you very much. Thank you. Now, the next person I think we hear from is Miss Studd, Queen's Counsel on behalf of the Mayor. And again, I'm not going to rise while we change over, but take your time, Miss Studd. Yes, when you're ready.
Mr. Chairman, it does not go unnoticed that the hearings of Phase 1 conclude just as those directly affected by the Grenfell fire commemorate 18 months since the tragedy. It's appropriate that all those involved in this process should pause and reflect upon how much more needs to be achieved to ensure that this cannot happen again. In this regard, we support the call for increased candour from the core participants as we move forward to Phase 2. The Mayor intends to divide his closing remarks into two parts. The first part looking back and reflecting upon the work and investigation that is being completed in Phase 1 of your inquiry. And then secondly, looking forward to Phase 2 and the change in emphasis from response to the tragedy on the night itself to an examination of who or what organisations should bear responsibility and be held accountable for the catastrophe of the 14th of June 2017. In some respects, the inquiry's division of its work into Phase 1 and 2, while pragmatic, has been artificial, and at times perhaps more than a little frustrating for a number of the core participants, and perhaps even yourself, because it's not been in a position to answer some of the very obvious questions that have been raised relating to why. Phase 1 has focused, as it was intended to do, on the events of the night and the immediate aftermath. And it will no doubt conclude that there are lessons to be learned about what occurred on the night and perhaps what might have been done differently. As the Mayor said in opening, and he repeats, and it's been reiterated by other BSRs in their closings, it is incumbent upon each and every one of us with a role here to ensure that we learn every lesson, even the difficult ones and the unpalatable ones, with an aim to achieve the central objective, which is to ensure that such an event can never happen again. To quote others, that this is the beginning of the end. Phase 1 has highlighted the actions of very many individuals present on the night who disregarded their own safety in order to ensure the safety and survival of others. The inquiry has heard accounts from survivors and from individual firefighters who put their own personal trauma to one side to provide evidence orally in writing, illustrating for the inquiry and the public the very many who put their own lives at very great risk. The Mayor was privileged to attend the inquiry in person and hear some of that very moving testimony. It would be wrong to single out individual accounts, but many of us present or following the inquiry more remotely were and should be humbled by those testimonies and the illustration of human courage that has been portrayed. However, what has been wholly absent from this phase of the inquiry has been any explanation for the seeming divergence of views between the TMO and Ryden on the one hand, whose newsletter indicated that after the replacement of the flat doors, Grenfell Tower was designed according to, quote, rigorous safety standards, and Dr. Lane on the other, who gave evidence that if the material used on the outside of the building had been known, the building should not have been occupied, because the fire brigade would then also have known what was facing them. If Dr. Lane's conclusions are correct, then the renovated Grenfell Tower was unsuitable for occupation and absolutely unsuitable for occupation with a stay-put policy in place. She has given evidence that Flat 16 could not maintain the required high degree of compartmentation due to the failure of the building envelope to adequately resist the spread of fire. Her wider evidence of non-compliance was damning. Obviously, the Mayor acknowledges that this is going to be the subject of detailed analysis in Phase 2, when the inquiry will hear more by way of explanation from the corporate core participants as to why it was that they considered the design and renovation of Grenfell Tower rendered it suitable and safe for the stay-put policy to be maintained. It is, of course, a matter for you, sir, to consider how far you can go and how far you should go at this stage in fact-finding relating to the condition of the building on the night of the fire and prior to it. However, the Mayor would invite you to consider that any criticisms you make of the first responders must be made in the light of the oral and written evidence of Dr. Lane. In particular, we would ask you to note that Dr. Lane did not consider it reasonable that in the event of the installation of a combustible rain screen system on a high-rise residential building, the fire brigade should be expected to fully mitigate any resulting fire. Although Phase 1 has heard some evidence relating to the training and organisation of the London Fire Brigade, this was limited to the discussion of issues directly relevant to the brigade's attendance at Grenfell Fire in its location in Inner West London. The Mayor notes that further evidence on these matters, including the expert evidence of Mr. Steve McKirk, will be considered in Phase 2. The inquiry will be aware that the organisation and structure of the London Fire Brigade, while not unique in the United Kingdom, is organised in such a way as to take into account the demography and the geography of London, and therefore recommendations that might work in London may be less workable elsewhere. Given the importance of your recommendations and the fact that they are likely to be considered nationwide, the Mayor would urge you to exercise great care before making any recommendations on the Fire and Rescue Service organisation, training and operation at this stage, and in the absence of any evidence in relation to the national position. Let us now look forward to Phase 2. Phase 2 must be about responsibility and accountability. That will obviously include the adequacy of the response, but the immediate focus must be on the design, the construction, the modification and the renovation of Grenfell Tower from its original construction in 1974 until its decimation by fire on the 14th of June 2017. In a letter dated the 18th of May 2018, the Prime Minister indicated that the hearings of Phase 2 that you would be sitting with 2 additional panel members. Her letter confirmed that the 2 additional panel members would be necessary in order to provide the necessary breadth of skills and diversity of expertise. And she went on to say this: I hope this decision will provide reassurance to victims and survivors of the fire, the local community, and members of Grenfell United, who have been clear with me and the Minister for Grenfell Victims, Nick Hurd, that you are the right person to lead this inquiry, but who also believe that in Phase 2 it will be beneficial to have additional panel members recognising the scale and breadth of the issues to be considered. In the particular circumstances of these appointments, The Inquiries Act requires that you give your consent. The Mayor would invite you to prioritise diversity when considering your consent to the appointments of panel members. You have already appointed experts to assist you as your advisory panel. The panel members for Phase 2 should bring a different element to the proceedings. Diversity is not just about appearance. Phase 2 will require an examination of a number of issues relating to how and why Grenfell Tower rapidly became the serious danger to life that it was on the night of the fire. But it will also look at the governance and management of the tower, the communication with residents, the fire advice, and the actions taken by the various authorities in the aftermath. In respect of all of these issues, you will be hugely assisted by panel members with relevant life experience and not merely relevant professional qualifications. While it is of course a matter for the Prime Minister, the Mayor would also welcome and encourage any measure of consultation permitted to the core participants prior to these appointments. Without apology, Mr. Chairman, I also revisit the difficult issue of venue. Once again, the Mayor supports the bereaved survivors and residents' plea for a more practical venue for Phase 2, which is able to accommodate more of their number in more appropriate surroundings, and in particular nearer to the location of the Grenfell Tower. This inquiry must prioritise public participation and be particularly concerned about the inability of a large number of core participants who resided in the tower or adjacent to it to actively participate in this process. Very many of those important people are currently unable to do so due to the location of this inquiry at Holborn Bars. It is absolutely not enough for the inquiry to say that the venue is satisfactory because it is rarely full. This is not about numbers and the venue being full. It is about the convenience for the core participants when they have competing daily commitments in their locality and community close to their home, and concerns about their mental health which have evolved directly as a result of the fire. They need to be able to participate without having to travel an hour or more either way to do so. We again urge the inquiry to relocate for Phase 2, and in the interest of transparency, the Mayor has previously invited the inquiry team to publish details of all venues already examined and rejected, although this request has been refused on the grounds of commercial sensitivity. In the event that it is unable to relocate for Phase 2, the Mayor repeats his request and invites the inquiry to publish or provide to core participants the information on what steps have been taken, the premises that have been contacted, to reassure core participants that the inquiry team have used their best endeavours to make efforts to relocate, but they have been unsuccessful in their efforts. We are appreciative of the scale of anticipated disclosure for Phase 2, but nonetheless remain concerned that it has yet to commence, despite the inquiry's recent letter indicating that the first tranche of disclosure will be made before Christmas. It is essential that the core participants have a realistic working timetable, including a timetable for rolling disclosure, as soon as possible to prevent further delays in the inquiry's work. Public safety demands that this inquiry proceeds as quickly as possible, and the inquiry team must ensure that slippage on dates does not derail the starting date of Phase 2. And lastly this, The inquiry must ensure that in phase 2, the bereaved survivors and residents remain central. In phase 1, their voices have been heard, both in the touching memorials and in the evidence they gave in relation to their experience of the fire itself. The inquiry's experts have also expressed how valuable this evidence has been in assisting with their work. In phase 2 also, their evidence needs to be placed right at the heart of the inquiry's work to provide justice for the dead and accountability for the living.
Thank you very much. And next, Mr. Maxwell Scott. Yes, Mr. Maxwell Scott, when you're ready.
Thank you. Mr. Chairman, when I made oral submissions at the first directions hearing in December last year, I emphasised the centrality to this inquiry of the bereaved, of the survivors and of the former residents. The Council is, and always will be, deeply sorry that its residents suffered the terrible tragedy of the Grenfell Tower fire. At the first directions hearing, I referred to the resolution passed unanimously by the full Council on the 6th of December 2017, which committed the Council to openness, candour and transparency. That resolution also stated the Council's commitment to full cooperation with your inquiry and to assist the search for the truth. Over the last 12 months, we have sought to honour that commitment by assisting your inquiry as best we can. Your team will be aware of the ways in which we have assisted, but I will, if I may, mention some of them today. We have provided the inquiry with a chronology relating to the flat entrance doors within Grenfell Tower. This has since been disclosed by your team to all core participants. We have provided the inquiry with a building control chronology for the refurbishment. We have worked with your team to identify councillors and officers from the Council from whom the inquiry might wish to request Rule 9 witness statements. To date, 27 Rule 9 witness statements have been provided from councillors and officers. More than 20 further witness statements addressing the Council's response in the first week after the fire are due to be provided to the inquiry in January 2019. In October, we provided the inquiry with a position paper which summarised the fire safety-related actions taken by the Council since the fire and exhibited relevant supporting documents. We have worked with your team on disclosure issues, including electronic search terms, and provided the inquiry with a 17-page statement summarising the further steps taken to disclose relevant documents to the inquiry since November 2017. As at the date of that further statement, which is the 20th of November 2018, the Council has disclosed a total of 38,299 documents to the inquiry. So your team will be aware that our approach is to provide assistance to them and you, rather than to duplicate your work. And we take the same approach to the Phase 1 closing statement. As I mentioned at the outset, the bereaved survivors and residents are central. They are central to all aspects of the inquiry's work. They are central to Phase 1 and to Phase 2. Their experiences on the terrible night of the fire are obviously central to Phase 1. Over the past months, we have heard very moving evidence about the harrowing experiences of individuals on the night of the fire. Your team will be assisting you to analyse that evidence in order to enable you to write your Phase 1 report. Your team will also be assisting you to analyse the detailed evidence of the actions of the LFB on the night of the fire. In both of those tasks, you will be ably assisted by the written and oral closing statements from the legal teams representing the bereaved survivors and residents, and the LFB's legal team. We do not intend to duplicate that work. Our written closing statement, as you will have noted, does not therefore seek to address every topic that falls within Phase 1. It aims to provide you with assistance. The issue of which topics to address in Phase 1 and which to address in Phase 2 has been discussed on a number of previous occasions. So you have always emphasised the importance of flexibility in addressing this issue. In addition, we have always understood that the fact that evidence was received on a particular topic in the course of Phase 1 did not automatically mean that you would address it in your Phase 1 report. The way in which the evidence has unfolded in Phase 1 indicates the wisdom of the flexible approach which you have favoured. As you know, the primary cause of fatalities was the spread of smoke within the building. Standing back from the detail of the Phase 1 evidence on this issue, the theme which emerges is that the chronology of smoke spread within the tower and the respective contributions made by the potential causative factors is more complex than many of us might have imagined. This complexity is perhaps best illustrated by the scale and range of further investigative work that your experts propose to undertake in relation to this topic in Phase 2. To give just a few examples, the smoke ventilation system requires substantial further investigation. Dr. Lane has recommended the instruction of a specialist lifts expert. There needs to be a location by location, floor by floor, flat by flat analysis of smoke spread within the building, which brings together the evidence of residents, the evidence of firefighters, the 999 calls, and the forensic evidence in relation to individual flat entrance doors. Dr. Lane captured the importance of not oversimplifying topics well when giving oral evidence about the flat entrance doors. She stressed the importance of location and said, "I don't want to give any kind of overall opinion on one measure. I think there's a really important piece of analysis per flat, per lobby, required to give a fair view on what those systems did." The G5 submission for the March 2018 procedural hearing invited you to seek to identify in your Phase 1 report ways in which the specified or actual design of the building works were non-compliant. That remains a laudable aim. However, what perhaps was not anticipated back in March 2018 was the extent to which the experts would describe their Phase 1 evidence as provisional. And not provisional merely in the sense that the experts would, as one would expect, be willing to consider any new evidence that came to light in Phase 2 before describing their views as final. Provisional in the sense that the experts themselves have actively expressed their desire to carry out further investigatory work and identified in detail the additional work that they wish to do. In our written closing statement, we have sought to assist you by dividing topics into two categories: those which we consider should be addressed in your Phase 2 report rather than in your Phase 1 report, and those which it would be appropriate and fair for you to address in your Phase 1 report. We have then, for understandable reasons, focused our submissions on the second category. Mr. Chairman, the spread of fire on the outside of the tower is very different to the spread of smoke inside the tower. Unlike the spread of smoke, this is not a topic that requires a flat-by-flat approach. Unlike the spread of smoke, the experts are not saying that they need to carry out substantial further investigations. In my opening statement on the 6th of June, I said that it was clear that the cladding system, as installed in the refurbishment, did not satisfy the functional requirement of Schedule 1, Part B4 of the building regulations, and that it was likely that a number of specific failures to comply with the provisions of approved document B would be identified by the inquiry. Questions about who bears responsibility for this state of affairs can only be answered in phase 2, not least because the potentially relevant witnesses have not yet given evidence to the inquiry. However, I believe that you can and should identify in your phase 1 report the fact that the cladding system did not satisfy the B4 functional requirement and did not satisfy the requirements of approved document B. Stating this may be an important step for the bereaved survivors and residents who, by the time of your report, will have waited over 18 months for that authoritative judgment to be made. But it will also have a wider significance. As is well known, Grenfell Tower is far from the only building now considered to have been overclad with unsafe materials. The latest monthly data released by MHCLG on the 8th of November indicates that as at the 31st of October, there were 457 high-rise buildings in England which had been identified as having cladding systems unlikely to meet the current building regulations guidance. 159 of these were social sector residential buildings, 9 were hospitals and schools, but the majority, 289 in total, were private sector buildings. This inquiry represents an opportunity to change many aspects of fire safety in a way which appears not to have been done following previous fires. A finding by you, sir, now, rather than in your phase 2 report, is likely to carry significant weight and to accelerate the process of improving fire safety in our country for the benefit of all of us. As I said in my opening statement, the ultimate achievement of this inquiry will hopefully be to ensure that when people design, construct, and refurbish buildings in future, a disaster like this never happens again. The Council is totally committed to that aim. Making the finding now can only help to promote that aim.
Thank you very much indeed. Thank you. Now, we are running well ahead of schedule. We were due to hear tomorrow morning from the tenant management organisation represented by Miss Jarrett. Is Miss Jarrett here? Well, Miss Jarrett, before you come up, are you ready to make your statement this afternoon?
I am, sir, yes.
Right, well, you're down in the running order to be allowed about an hour. Does that sound enough for you?
Certainly does. I hope to end.
Right, well, in that case, I'll rise for 10 minutes. Gives you a chance to find your way out of the back of the room, and we'll sit again at 3:05, and then we'll hear you then. All right? 3:05, please. Yes, Mr. Millett.
Mr. Chairman, I wasn't expecting to rise, but given the fact that we have made significantly better progress in terms of timing today than we had anticipated, we have come to Ms. Jarrett's submissions not just earlier than we would have expected, but a day earlier than we would have expected. I've spoken to Ms. Jarrett, and it doesn't inconvenience her to do her submissions as slotted in tomorrow morning, when most people, all people, were expecting that to be done.
Yes.
There is, I think, a view that it is right to stick to the timetable as published. People have made personal arrangements to come tomorrow to hear Ms. Jarrett, and it's right that that should be respected. And so I'm going to invite her and you to defer her oral submissions until tomorrow morning in accordance with the published timetable.
Right, thank you very much. Well, Ms. Jarrett, I'm grateful to you for being willing to carry on this afternoon, if I may say so, in the best traditions of the bar, being ready to address, make your statements when called on to do so. But I think in the light of what Mr. Millett has said, and in view of the fact that there are a lot of people here who've come to hear closing statements generally, and I think several who were looking forward to hearing you tomorrow may not be here today, I think if, with no disrespect to you, I think it would be better if, after all, I put you back to tomorrow. I hope that won't inconvenience you.
Of course not, sir. I'm entirely in your hands.
All right. Well, then, that's what I'll do. We will break now, then, for the day, and we'll resume tomorrow at 10 o'clock, when we shall look forward to hearing your statement. Right. Thank you very much. 10 o'clock tomorrow, please.